workshop, this seminar on the latest trends in investment arbitration in Latin America under the auspices of the Dean for International Programs at the George Washington Law School, Rosa Celorio, who's our hostess today. This is going to be a great treat. I mean, we have perhaps some of the more renowned, respected practitioners in investor state arbitration around the world. We have three amazingly interesting lawyers with us. We have Nathalie Sequeira, who's the senior counselor at the International Center for the Settlement of Investment Disputes at the World Bank. We have Claudia Frutos Peterson, who's the managing partner of Cortis Malay Provo Washington office. She has acted on behalf of a series of sovereign states in ICSID arbitrations, and also she has led numerous commercial arbitrations. We have Eduardo Silva Romero, who's the head of the Deckard International Arbitration Practice in the Paris office. He has acted on behalf of numerous sovereign states, investors. Both him and Claudia are authors of a series of numerous articles and book chapters. They both have doctorates from the University of Paris. Nathalie Sequeira is an alumnus of the Georgetown Law Center, and she has wide experience acting as in-house at the ICSID. So we have amazing speakers. We are going to actually follow a somewhat different approach. We want to cut to the chase, get right at it. We don't want to waste time in long-winded expositions. We have a series of rather very pertinent, up-to-date questions. We're going to pose these questions to our speakers. We're going to engage in a conversation, and hopefully this will be this will be something that will something that would really answer your questions and perhaps engage you as you move forward in your studies, perhaps to pursue a career in international arbitration. So let me just get started here and perhaps pose that first question to Nathalie Sequeira from ICSID. And it has to do with what do you think has been the impact of the COVID pandemic in terms of the ICSID docket? Are we going to see COVID-related cases that have been litigation or disputes that arise as a direct consequence of the COVID crisis?
Thank you, Rafael. For a year that was so highly unusual in so many respects for all of us, it might come as a surprise to many that in terms of the caseload trends, 2020 was a similar year in terms of caseload for ICSID. Since the first registration of the first ICSID case in 1972, ICSID has registered a total of 800 cases approximately. In 2020, we registered a record number of cases of 58. That represents about 77% of the total cases that we have registered throughout the life of ICSID. And while this is a significant increase, if you compare it to 2019, when we registered 37 cases, this is not far off from the 56 cases that we registered in 2018 or the 53 cases that we had in 2017. So on the basis of these numbers, while there might be the perception that the ISD might be increasing exponentially because of the COVID crisis on an exponential way, this would not be accurate, at least now. For now, what we would say on the basis of these numbers is that, as always, investor state arbitration is cyclical, and it responds to different phenomena depending on regions of the world, countries, and not as a whole trend. And that also applies to Latin America. I would say that it's important to clarify that there's a lot of debate in the media and speculation. I would say that there cases in ICSID arising out of the COVID measures. So far, we have not seen that, and our understanding is that no other institution has reported those cases. Again, this is on the basis of public information. And this obviously deserves, and there have been numerous conferences about the subject, but I wanted to clarify that. So in a nutshell, last year we had a record case, but not on the basis of COVID cases. I would leave it there. And maybe just a couple of additional numbers there. We are seeing a trend in terms of more cases coming to ICSID to administer UNCITRAL cases, non-ICSID cases. That's something that we are seeing as a trend. That also applies for Latin American states. In terms of the Latin American region as a whole, approximately 1/3 of the ICSID cases involve Latin American countries. And that's, in a nutshell, what I can tell you about 2020.
I wonder if perhaps Claudia and Eduardo might want to comment about perhaps the consequences, if any, of the COVID crisis in the docket of ICSID, or what you guys have seen in terms of disputes that might arise as a consequence of the COVID crisis. Perhaps, Claudia, you might want to add something, or Eduardo, whichever.
Thank you, Rafael. I don't know if it's my system, but I couldn't really hear you very well. But first of all, I want to thank you and Rosa for the invitation. It is always a pleasure to do this kind of discussion, especially with colleagues like Eduardo and Natalie, who I have known for a while now, and it's always fun to at least see you all, through virtual meetings, like this. If I could, I think your question was whether we're seeing any impact about COVID, the COVID cases in investment arbitration, in particular in the region and Latin America. I mean, I heard what Natalie was saying, that ICSID is not necessarily, or the numbers that ICSID had in 2020, they are not really necessarily related to COVID cases. What I have seen so far is it goes with Natalie's observations. I think we have heard a lot about seminars, discussing what COVID can really have an impact in bringing more cases against the states, around the world in Latin America. So far, of course, we have been speculating that that could be the case in light of the different measures that governments have been taking, in order to confront the pandemic. Having said that, I haven't really seen any particular cases, being registered because of the measures that government has taken in light of COVID. Of course, a totally different discussion is going to be if those cases, they're really happening, what is the type of defenses that a state can have in light of the emergency situations that they confronted, in light of COVID. We all know, that in light of, under international public law, of course, there are defenses that states can be using, could use in order to defend those cases. We also hear a lot in the discussion that maybe tribunals are going to be applying a more differential kind of, attitude vis-a-vis the situations related to COVID cases, if I can call them that way. But so far, Rafael, personally, I haven't seen anything like that. I think it's a lot of speculation, so far with that particular subject. I'm not saying that it's not going to happen. The probably is going to happen, but so far I haven't really seen any cases. I don't know if Eduardo wants to add something in this respect. I know that Eduardo also acts a lot as arbitrator, so I don't know if he has any more insight than Natalie and I would on have.
Thank you, Claudia, and thank you, Rosa and Rafael, for this very kind invitation to participate in today's discussion with Claudia and Natalie. I've seen only investors analyzing the possibility of making claims against states because of some measures taken by the states because of COVID. I must say that those investors, or the investors I've seen, are very hesitant about filing these claims on the proposition that, as Claudia mentioned, the tribunal very likely will not feel comfortable second guessing what the state did in extreme circumstances. I mean, those claims against the state because of the pandemic will not be popular, because we all know the states did what they could in the circumstances. Can they be ordered to pay damages 4 years from today because perhaps the measures could have been different, or the measures are characterized ex post facto as being disproportionate? Is something that I personally don't see. I mean, we, as someone said very cleverly, we are all the actors of the same catastrophic movie, and we are watching the movie.
And the movie is not over.
Unfortunately so.
Exactly.
Eduardo, in the past, you have suggested, for instance, that Latin America could very well be a rather peculiar laboratory for testing some of the basic notions of investor-state arbitration. Could you explain to us what you mean by this?
Yes, I think there is a paradox that comes out from investment arbitration and our region, Latin America, which is, and this Claudia and Natalie know better than myself, which is that the cases against Latin American states were the occasion for many of the today well-known theories of investment arbitration to appear. I may mention a few and then make a few considerations on them. One, for instance, this artificial distinction between treaty claims and contract claims. As far as I recall, that was created in the Vivendi versus Argentina case. Obviously, it is presented as a recognition of some provision of the International Law Commission articles on state responsibility. But, you know, Crawford and Fortier and others created that idea, with which I do not necessarily agree, but it is there. And without it, investment arbitration wouldn't have the scope that it has had over the years. Another example, also a bit extreme, comes not from Argentina this time, but from Claudia's Mexico, which is the case Tecmet versus Mexico and the creation of the theory of legitimate expectations. You know that in these treaties, there is this protection that the host state has to accord to the investor fair and equitable treatment of the investment. And obviously based on arguments from advocates, that tribunal accepted the idea that part or a content, the content of this protection is that the state has to respect the legitimate expectations of the investor. And obviously this expression is so broad that may give rise to very broad protections. So that happened in Latin America. And a third example comes from a case involving which was the exception in the past, a Latin American claimant, Mafezini, against the Kingdom of Spain, in which something that the ICSI Convention characterizes as recommendations, meaning provisional measures, suddenly became orders, which has been another, in my view, misunderstanding of the system. So what are the observations on these three very arbitrary examples? It is that Latin America gave rise to many of the theories that can be characterized today as favorable to investors. But one should also recognize that without those theories, at least the two first theories, perhaps investment arbitration wouldn't have the importance that it has today. Since then, other regions have been helpful or more helpful than Latin America to create theories in favor of the states. But we don't have the time to comment on those, and this is beyond the scope. Thank you, Rafael.
Maybe that's the subject of a future paper or something. But perhaps now that we're talking about, trends and the latest events, perhaps what, Claudia, we would love to hear from you in terms of your analysis of the impact the new treaty between, the new treaty among Mexico, Canada, and the United States might actually have in the arbitration jigsaw puzzle. I mean, what sort of expectations should we have, if any?
Well, expectations, I think we always should have in investment arbitration. I mean, Eduardo just went through three particular topics, that I don't know. I don't know if in the early days of ICSID, the founders of ICSID will be thinking that this type of cases were going to be the cases being resolved under the ICSID convention. And that, of course, is, as Eduardo said, is a different subject, that it could just take us the whole day just to start the debate on it. But when it comes to treaties, we saw what NAFTA created in the region. We saw how the provisions, the investor-state arbitration provisions contained in the NAFTA treaty, they actually were used and expanded, in a lot of the free trade agreements that we see in the region. Not only in Latin America, but actually more broadly, because of course, those were positions that they will be taken by the United States and Canada. And United States and Canada having, a lot of the power, if I may say like that, when it comes to negotiations of international treaties. So Mexico, of course, accepted those provisions in NAFTA. Now we have seen that NAFTA has been superseded. NAFTA, in principle, has been terminated. I say it in principle because we know that there are pending cases under NAFTA, and the new treaty, will allow them to develop, will allow them to be finished. But when you look at the new provisions of the TEMEC, as we know them, as we know the treaty in Spanish, I think I always get confused with all the different terminologies. I think it's USMC in English. I have to write it down, otherwise I forget. But anyway, the new NAFTA. So the new NAFTA has very interesting provisions because to me it's something where states like developed states, like the United States and Canada, they are trying to push, in this new tendency of investment arbitration. But at the same time, one could claim that they want to still have some sort of system, that continues to be applicable in case that you go with disputes with investors. To start with it, the new NAFTA really is sending a strong message. United States and Canada, they are not going to have a system like we had it in the NAFTA. So there is a possibility to do investment arbitration, but it's mainly for US and Mexico, and then when you look at it, you will realize that even that system has been split apart, so we don't have time to go into details into how it really is going to be implemented. But I think what is important, Rafael, just to have a discussion here with our colleagues, is that I do believe that TEMEC is now really bringing new tendencies for investment arbitration. And I will expect that those new tendencies are going to start penetrating, if I can say that, the tendencies of new treaties in the region. Or in other words, we might be to a point where the free trade agreements that we see in Latin America, they are going to be modified, in order to incorporate some of the new tendencies that we see in TEMEC. And that is important also because we know that the system has gone through a lot. It has gone in the recent years, it has gone through heavy criticisms. And I think what TEMEC is trying to incorporate is part of those criticisms. So Eduardo was just talking about, legitimate expectations. So when you think about that standard, only, and you compare the new TEMEC, you realize that, the states are also concerned about what does really mean, fair and equitable treatment. Can you incorporate legitimate expectations when you are really applying or trying to see if there is a violation of fair and equitable treatment? So all of that, I think we are stepping into new ways, that we're going to be seeing more and more, in my opinion, in some of the treaties in the region. So I will stop there. I don't know if Natalie and Eduardo would like to react with that. But I stop there.
Eduardo, Natalie, would you like to react to the, to the proposition put forward by Claudia, which, I find, will have a huge impact in the region. There's a question that is also an essential question that somehow has stayed under the radar screen that perhaps Natalie can throw some light on it, which is, the whole arbitrators network. In other words, do we see a lot of Latin American international arbitrators? Who are these arbitrators? Do we have a sufficient pool of Latin American lawyers accessing those panels? Who are the arbitrators deciding most of those disputes arising in the region? What's going on there in that kind of sort of exclusive club, legal club? What are you seeing, Natalie? Any new trends?
Well, in terms of trends, and I've been at ICSID since 2015, I can tell you that we are seeing an increase in the numbers of Latin American arbitrators and counsel experts participating in this field. That's, and I'm sure Eduardo and Claudia can also confirm that. I also agree that the pool is there, that there's more than we know. There are many people that are involved in the field that know a lot about the field. As you said, it's maybe perceived sometimes as a club because it's not so easy to jump from private practice or from being a professor or in any other area of practice to become an arbitrator. And as 15 years ago, when I started doing this, there were only a few people that were appointed as arbitrators. Now we're seeing more diversity, not only in terms of the nationalities, but also in terms of the individuals that are being appointed. Sometimes when we issue our statistics, we see several times the repetition of names. In the last years, we are seeing more individual appointments of different persons. That means that the pool is expanding, it's not so restricted, but there's a lot to be done. And I think we all have a responsibility in terms of training, of expanding the field to new generations. And in Latin America particularly, I think those of us that come from the region, we need to reach out to the region and not try to bring it to us, but the opposite, like start forming and providing the tools for the Latin American students and professionals to have their own education in their own countries and have the same experience as in other areas of the world.
Eduardo, I know that you have been, you're not only a counsel, you have been appointed as an international arbitrator in a series of cases. I mean, what can you tell us about precisely what Nathalie is describing in terms of what are the trends that you're seeing in terms of, the pool of arbitrators from the region, both in investor state, but also in commercial arbitration?
No, generally, I entirely agree with Nathalie, Rafael. I think the pool is increasing. In commercial arbitration is probably easier to increase the number of people acting as arbitrators, because the cases are, I don't say it in a pejorative fashion, but they're purely commercial, whereas investment arbitrations involve political serious issues, and so the people to whom those cases are entrusted normally are very experienced people. And another issue in investment arbitration, and I must confess I've been a victim of it, is the double hatting or issue conflict issue. Because we all know that when one acts as arbitrator, one holds the true position. When you are an advocate, you are advancing the best arguments you found for your client. But at the same time, it's true that the appearance that especially the states may have of the fact that someone who is counsel one day is acting as an arbitrator, another day is problematic. But I see it especially problematic in the sense that if you are representing a state, but as arbitrator you have held a theory which is not necessarily favorable to the state, but your client will not be happy with the fact that the other counsel is showing you a reward, holding something which probably may go against your client. So accepting these cases has become something, I'm certain Claudia agrees, very difficult for those who act as counsel in these cases.
What do you think, Claudia? How do you see this?
Well, I thank you, Rafael. I wanted to, I mean, I am in agreement with Nathalie and Eduardo, but I just wanted to add how, I'm pleased. I mean, Nathalie, especially Nathalie, but Eduardo and I were not that old to tell you that that we have seen, through the years, a huge change. I mean, Eduardo, you were just bringing this laboratory idea, about Latin American investment arbitration, and I think you're right. I think a lot of the things that we see in investment arbitration, they started in Latin America, and probably the fact that we had that tremendous crisis in Argentina in the 2000s, and that of course got into register, I don't know, more than 40 cases against Argentina, and of course you have all the jurisprudence, constant, whatever we want to call it. There is always a debate about that, but you have all those decisions, that came there. I think Latin America also, when it comes to lawyers from the region, when it comes to people who are interested in the region, it's actually a step forward, than in other regions, in my opinion, because we have gone through a lot. The countries in the region have been sued a lot. So you have examples: Argentina, Ecuador, Venezuela. So you have all those cases. So it's logical that in the region there is a lot of interest, expectation, etc. What I have seen is that in the last 10 years, I mean, it has been a tremendous change, not only in the number of cases, as Nathalie has been explaining, but also the participants and also the lawyers. You know, I have to confess, I mean, I'm very happy to see that a lot of lawyers in the regions, they are, you know, they have some sort of experience in investment arbitration. And that, of course, is good. The states, for the good or for the bad, you know, they, of course, they had their experiences as well. And now I think, Natalie, I don't know if you agree with me, but a state seems to be also more responsible vis-a-vis ICSID in the sense of appointing, you know, arbitrators to the list of arbitrators. And so I think there is more participation from the region. And I think the same that you see with Latin America, the same evolution, I expect that we are going to be seeing it with countries from Eastern Europe, you know, because I have the impression that what Latin America was dealing with 15, 20 years ago, now is that region that is really, you know, evolving and getting a lot of cases. And so it's part of the evolution of those treaties that we were mentioning a while ago.
Now, putting COVID aside, I want to go back to the ICSID docket and to Natalie more specifically. You know, can you tell us a little bit in terms of what are the latest trends in terms of, you know, what industries are mostly affected by claims of arbitration? What are the industries that you're seeing now more often in your docket? I mean, what are the countries that you're seeing more hardly hit by ICSID disputes in the docket right now?
Just like in past years, I have to say that in 2020, we saw a wide diversity of economic sectors that were subject to disputes. Oil and gas and mining, traditional, have taken the largest share of ICSID cases, and in 2020, that was not the exception. We have seen a little bit of a trend in terms of construction-related cases, so that's increasing compared to previous years. And for Latin America, I would say that it depends on the country. The sectors, again, depends on the development strategy of each country, and we see the disputes arising out of the main industries affected in each country, and also the times or the years in which the measures are taken. Just like we saw with the cases in Spain related to renewable energy, that responded to an economic sector that was developed by Spain during certain years, and we might see different trends in different countries depending on those policies. So again, Latin America, I would not. I would have to go country by country depending on the sector that has been affected, but overall, oil, gas, and mining, followed by electricity, power, and other energies are continue to be the traditional areas that we see. In terms of countries, we, as you probably know, Colombia, Peru have been two countries that have seen a steady increase of cases. In the case of Colombia, if I'm not mistaken, our first case was in 2016, and all of the Colombian cases are currently pending. So that's very different from what Argentina is experiencing now after having more than 40 cases at some point. And now we see very few cases pending, same for Venezuela. So again, it depends on these stages, different waves for different countries.
Let me ask Eduardo, do you expect that the Spanish phenomenon is going to be repeated in Latin America? Do you expect a raft of renewable energy type disputes arising in Latin America?
This is a question that was put recently in a conference, and I found it very, very interesting, trying to guess the future. And the way to do it perhaps is to determine the different elements of these cases against Spain to see if the same elements appear today in some Latin American countries. What are those elements? First of all, there shall be a law enacting some incentives for investors to invest in the field of alternative energy means. Second, there has to be an economic crisis. Third, in Spain, what happened was that because of the economic crisis, a new law would cut some of the incentives. And then because of that, some investors commenced arbitrations. Interestingly, most of those investors were really funds behind the different ventures. So they were not, so to speak, institutional investors, but rather opportunistic investors in many of the Spanish projects. And the other element, obviously, there has to be a treaty that can be relied upon by the investor to commence arbitration. Where do I see a similar situation? Unfortunately, Claudia, a similar situation seems to exist.
I knew it.
In Mexico.
I didn't want it to say, but I knew that you were going to talk about
in Mexico, because
Go
you had
ahead.
the 2014 reform, incentives to come here. Then there was the COVID crisis, economic crisis, and there is this new new measures that the state has adopted against that 2014 reform, so to speak. So now, are there investors having a treaty to rely upon? We seem to see some already filing notices of dispute. So will this give rise to another saga such as the one that we saw in Spain? Perhaps. Argentina seems to have a similar pattern of behavior, but they are a bit delayed in relation or in comparison with Mexico, because they seem to be considering changing the framework. And unfortunately, Natalie, given the statistics, Colombia seems to be also considering changing their regime of incentives in that field. And all of these countries have treaties that can be relied upon.
But Eduardo, if I may, Rafael, I wanted to bring to the discussion, isn't that then a situation? I mean, if you have so many examples, and I'm not saying it just because I'm Mexican and I feel it from Mexico, but if you have so many examples, that where you are seeing the states considering making these changes in the sector, so isn't that some sort of tendency on the need of regulation on that particular sector? I think what I'm trying to say is there a justification then? Because we are in a position right now where the state might be suffering, because whatever they thought it was the correct way to regulate the energy sector is actually not the case. You know what I'm saying? I mean, I know that Spain is very particular because they have to implement the measures the European Union, adopted. But I'm wondering about the other countries. I mean, I don't know.
Yes, what I can say, Claudia, I mean, from my perspective, but I'm not an expert in these matters. I see some inconsistency in how many countries, not only in Latin America, but in other regions, inconsistency in their policies regarding energy. Because at some point there was this trend towards protecting the environment, and we wanted alternative ways of generating energy. But then we realized, and this unfortunately coincides often with a change of administration in the state, we realized that these alternative ways of generating energy are more expensive than the traditional ones. And that cost doesn't want to be borne by the state. So I think what we are lacking is a consistent policy in the sector across all countries. But that obviously, again, is beyond the scope.
Before we move on to questions from our audience, I have one last question for Claudia, and that is, what, if any, you think might be the impact of whatever happens with investor-state arbitration in the region on commercial arbitration having to do with the region, with regional parties? I mean, what's the interaction between investor-state and commercial arbitration in the region?
Thank you, Rafael. I think the answer will depend on when you ask that question, to be honest. Because if you had asked that question, I don't know, 5 years ago, 10 years ago, I will think that, yes, it is having an impact. Whatever we're living in investment arbitration, there was a lot of discussion about the system, legitimacy, etc., mainly by some particular Latin American countries. So then you had a reaction or an effect in the practice of international commercial arbitration in the region. I confess that right now, for me, and I'm interested in hearing from you and maybe even the participants what they think, but right now, to me, that's not the case. I think international commercial arbitration in Latin America has had its own development. I think the system is mature enough to separate whatever is happening at the investment arbitration level and the international commercial arbitration level. I'm not saying with this that you will not have jurisdictions in Latin America that might be a little bit more restrictive vis-a-vis certain principles in international commercial arbitration, especially principles coming from France. Eduardo, I know that you are very pro-commercial arbitration, which, I also love to practice, but maybe some Latin American countries are not as ready as French practitioners will love to have, in international commercial arbitration in the region. But right now, Rafael, I think, just to summarize, I don't think we are seeing a lot of reluctancy in the practice of international commercial arbitration just because of the problems that some Latin American countries have faced in investment arbitration. I don't know if Natalie or Eduardo agree or disagree with me, but that's why I think it depends when you ask the question, because I think the answer will go with what we're living now.
There's a question from the audience, which I think is pretty relevant. There's someone saying, listen, yes, there's a rise in the amount of disputes, amount of cases. There's a rise in the culture. There's a change in the legal culture in Latin America. There's an openness with respect to arbitration, but yet there is skepticism. And there remains a high level of skepticism in the region. And the question our audience is making is, has the Calvo doctrine seen a revival in Latin America? Can we talk about a revival of the Calvo doctrine in the region? Let me start with Claudia, and then we'll move on.
I have to confess that I don't think so. I think that we have left that discussion. At some point, when we saw Venezuela leaving exit, Ecuador, Bolivia, I know that the discussion came back. Are we talking about a coming back of the Calvo doctrine, in the region? I always saw that, the situation that we were facing at some point in investment arbitration, and in particular with those 3 countries, it was also related, in a way with, political internal positions, that those countries, they also wanted to take. I will say in parenthetical that some of the criticisms, to the system, to me, they were valid criticisms. I think even today, we have criticisms to the system that the community should really address, because otherwise, we risk, to wrest legitimacy to the system. But so far as I understand, and I know that Eduardo is more a philosopher than I am, I don't think we are there anymore. I think that's something that happened, of course, Latin American countries, they were very into it, in the 70s, 80s, but the economy has changed so much. The states have concluded so many international agreements, where they do recognize certain obligations, responsibilities. So I think it's difficult, to try to incorporate what we all know about the Calvo doctrine, for example.
What does our legal philosopher think? Eduardo, what do you think? Are we seeing a revival of the Calvo doctrine in the region?
I'm not a legal philosopher, but I don't need to be a legal philosopher to agree with Claudia completely. I don't see the ghost of the great Professor Calvo, whose statue actually is in, probably you all know, in the Peace Palace. If you go through one of the corridors, one of the statues is Carlos Calvo. Who would guess that Carlos Calvo would be in such a prestigious place? But anyway, leaving that aside, what I see myself, and that applies also especially in Europe, is that investment arbitration to survive requires support from the states. If the states don't give support to investment arbitration simply disappears. Second point, the states are the main users of investment arbitration. So if the states are not satisfied with how the system is working, we have a problem, because the system may lose the support from the states. So that's the equation that I find very complicated to resolve. So what has happened in Latin America, Ecuador, Bolivia, Venezuela, is just that. 3 states were dissatisfied with the system, and at some point they left it. What has been the consequence? Did arbitration disappear against the state and the state entities in those countries? No. What we are seeing today, and this really fits well with one of the answers by Claudia, is that commercial arbitration involving a state and state entities is coming back, including commercial arbitration with exit clauses, which is pretty exceptional. I mean, I've seen cases in Peru where you have exit arbitration clauses, which I understood, but Natalie and Claudia know this better than myself, was the first purpose of the exit system was to have exit clauses in investment contracts. So, but arbitration is still there. So, worst case scenario, what I see is we're going to have perhaps more commercial arbitrations, meaning more cases based on contract, less cases based on treaty.
Although that will not resolve the issue that you were discussing from the beginning. I mean, what do we do with treaty claim, contract claim issues? So
I agree.
Natalie, how do you see it from your vantage point in Foggy Bottom, Washington? I mean, from the exit headquarters. Do you see the ghost of Carlos Calvo around, or?
No, we haven't seen it around. What I concur with Eduardo and Claudia in terms of how you read what's happening right now. More than a skepticism, I would call it a criticism of the system, a natural criticism of the system that is making the users question themselves how to improve the system, to continue using it and adapt it to the current circumstances, the current economy, the movements in terms of geopolitical forces. I mean, it's an adaptation of the system in terms of what's happening in real life, and that the answer to that has been all this movement to the amendments of the rules, including exit rules, the UNCITRAL rules, and countries coming together to propose their solutions to the issues that they have experienced on the basis of the cases that they have had and the new needs that they have seen for the future. So more than skepticism, I would call it constructive criticism, if you will. And countries can, as owners in a way of the system, can put their act together and then put the tools in place that they need for the future and for the investors. I'm not mentioning here the investors because of the nature of the system, but I think we have seen many actors coming into the discussion, both from the academic sector and the private sector, together with the states to improve the system.
Before we move on to our concluding observations, I would like to revisit Eduardo's laboratory and take a look at the fork in the road figure. I mean, are you seeing an evolution in the use of the fork of the road provision in the various BITs, bilateral investment treaties? Anything interesting happening more recently?
Yes, no, I just wanted to mention a small novelty in the region. There is an award. It's not an exit award. It's a PCA award. In the case Iberdrola versus Guatemala, which is called Iberdrola 2. You know that in this field of investment arbitration is more than the series that we all watched during the pandemic on Netflix and other platforms. So in this Iberdrola 2 case, a tribunal presided by Gabriel Kaufman-Colla, to my knowledge, applied for the first time for the first time in the region, a fork in the road provision to strike out a claim by the investor. So it's interesting to see that. I mean, to my knowledge, the other case in which a similar decision had been made was in the Panteshniki versus Albania case, but since then, we hadn't seen cases in which the fork in the road clause was applied so clearly. There's another case in which I participated, Supervision y Control versus Costa Rica, which also somehow applied that provision. But this Iberdrola case has a very Kaufman-Coller in-depth analysis of the issue, and I just wanted to recommend the reading.
So now in just perhaps each of you guys in a minute and a half, what does the future hold? I mean, what do you see in the next few months, few years in our region, in our neighborhood? Maybe I'll start with Claudia.
Thank you, Rafael. Well, if I could, guess the future, I will, of course, be very happy to do so. Unfortunately, I don't have those powers, but but just thinking about it, I do think for Latin America, I believe that the practice of international commercial arbitration is going to continue to expand. Also as a way or as a reaction of what we have seen in investment arbitration in the region. I do think that states are going to be more participative in way to try to modify or to amend their treaties, in order to put them up to date, if I can call it that way, to make to have provisions that they are more that recognize more the regulatory powers of the states, that recognize more interpretation of certain standards that we see in all these bilateral investment treaties or free trade agreements. I think states are going to be more participative. In a way, we have seen it, as Natalie was saying, I think Latin American countries have been very present in the reform, the proposed reform to the rules in ICSID. I also have the impression that the Latin American states have been participating a lot in the conferences that UNCITRAL has been handling, in order to modify at least processes in investment arbitration. So I want to keep it positive. I want to keep it positive for the region. I also think Latin American countries and practitioners, we are going to develop more skills, in order to be more active in this type of cases and adapt to the circumstances, because I think the pandemic is here for a while. We all have to learn how to deal with that, and I think the region is mature, in order to handle complex cases and handle situations like the one that we are living right now.
And Natalie, what do you think? What do you see? What does your crystal ball tells you? If anything.
Well, I agree 100% with what Claudia said, and maybe I would add that in view of the impact of COVID in the region, we will probably see, I wouldn't call it a race, but a lot of thinking around how to attract foreign direct investment in the next few years to the region, bring it back. And together with that, I'm sure that with the experience that Latin American states have in ISDS, they will also think on ways to settle disputes arising from those investments. And the road to settle those disputes will be very different from, it will be a more thoughtful process. That's what I would say than it has been in the past. So we probably would see better clauses in contracts. We will see a better use of the instruments that they have in place, bilateral investment treaties, multilateral treaties. There's more communication from what I've seen in these conferences and in our amendment process among blocks of states and blocks of countries with similar interests that get together and advance their interests and their criticisms, if you will. And together with that, we might see trends. A question mark that I would put on the table is whether conciliation and mediation in the region would ever be used. We have seen a lot of questions brought to ICSID from other regions of the world. So that's a question mark right now because we don't have that many cases. And the use of all these new tools that are being put into the amendments, like accelerated proceedings and so on, that we still do not have experience with. So there are many question marks still, but I think with the experience of Latin American countries, we will see a lot of new approaches to investment arbitration.
And finally, Eduardo, what do you see in the next few months, few years?
Nothing really very different from what Claudia and Natalie mentioned. I would only add one question that perhaps we didn't touch upon, which is how the investors in the region will look at investment arbitration, because the states are the ones creating, supporting, or destroying the system, that we know. But then what will come out of those discussions? Because if we took, for instance, the latest free trade agreements executed in the region containing an investment chapter, there are now so many protections in favor of the state in these chapters that if I were an investor, I would think twice before commencing an arbitration against the state. To the point that I wonder, as Natalie suggested, if many will not prefer to negotiate a good contract with the state and introduce a very good ICSID additional facilities arbitration clause, for instance.
I mean, we really want to thank you for your time. I mean, it has been a wonderful conversation. It has been a great experience. We really hope our students enjoy this as much as we have. I mean, I'm sure Dean Celorio agrees with me. And without further ado, I want to thank you and, wishing you extraordinary outcomes in your pending matters. Thank you so much.
Thank you. Bye.
Thank you all. Bye-bye.
Thank you all.
Bye.
Thank you. Bye.